The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hi, this is Andrew with Learn About Law, and today I'll be discussing what changes may have occurred for Iowa foreclosure law for 2022. And I'll also be talking a little bit about the process in general, the foreclosure process. So, really to cut to the chase, there have not been any noteworthy changes to Iowa foreclosure laws for 2022, but it's still important to be aware of Iowa foreclosure law if you find yourself in a foreclosure situation. So, let's kind of dive into the process here. So what happens before the foreclosure? Well, once you miss a payment on your mortgage, your servicer will provide a grace period, usually of a certain number of days. And then every month you're late, the servicer can charge late fees. The amount will be in your loan documents and mortgage statement. When you miss your mortgage payments, you are in default of the mortgage agreement, essentially. And then when the mortgage agreement is in default, many servicers will want to check on the property to make sure it's in good condition, and can do this by basically driving by the property, right? Servicers can also charge the borrower for broker price opinions and property preservation costs, essentially, if the property is falling into disarray. What starts the foreclosure process ultimately? So, federal law permits the foreclosure process to begin more than 120 days that the borrower's loan is in default, basically. This provides the borrower time to apply for loss mitigation with the mortgage servicer. After that period has expired, the mortgage servicer must send by mail of notice of default, a default, and the right to cure the default. The right to cure is to reinstate the mortgage by paying back the default amount. The right to reinstate is a period for at least 30 days before a lawsuit can be filed. Once the reinstatement period has expired, the mortgage servicer will send a demand letter allowing the borrower to repay the loan in full. Otherwise, the mortgage servicer will not be entitled to collect attorney fees. Under Iowa law, the borrower should receive notice about foreclosure mediation and counseling. It is important for the borrower to appear in court and defend the lawsuit if he or she does not want to lose their home to foreclosure sale. To defend the lawsuit, the litigation process is initiated. If you are a borrower facing the foreclosure, it is best to seek advice from an experienced foreclosure defense attorney. So, next at the auction, the mortgage servicer will make a credit bid. The bid can include the total amount owed, including fees and costs of the lawsuit. The bid could also be for a lesser amount. It's important to note that in Iowa, the mortgage servicer, that's the lender, may be the highest bidder, but it is not sufficient to cover the debt owed by the borrower. The lender can then get a deficiency judgment against the borrower. Once the lender makes the highest bid, the property is then considered bank-owned or real estate-owned, REO. If the bid is for more than what the borrower owes, the borrower gets the surplus funds after all liens on the property are paid. So, is there any way to stop the foreclosure process? Well, the first step is to apply for loss mitigation with the mortgage servicer. A borrower might be able to obtain a loan modification or other measures. A borrower can also reinstate the loan after 30 days after the notice of default is received from the mortgage servicer. Another option is to redeem the property. This means you must pay off the full amount of the loan to prevent the foreclosure sale of the property. There are some states that have a redemption period. This redemption period allows the borrower to buy back the property from the bank. In Iowa, if the bank proceeds with a judicial foreclosure with redemption, the borrower has up to a year to redeem the property back from the bank. Also, the lender will waive the deficiency judgment and the right to redeem in 3 months if the property is not for agricultural purposes. Another option to avoid foreclosure is bankruptcy. Filing for bankruptcy a few days before the sale of the property is to occur will stop the sale. There is an automatic stay that the bankruptcy court orders that prohibits creditors from doing certain things like proceeding to a sale in a foreclosure proceeding. There are different options for filing for bankruptcy, so it is best to consult with a bankruptcy attorney to decide which option is the best fit for you. That's it for now. Thanks for watching. To learn more, check out our website and information on Iowa Foreclosures. If you have any questions, please leave them in the comments below. Like and subscribe, and have a great day. Thank you.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.